Our next speaker, get very excited for. I've seen him speak multiple times before. He's always very articulate and a huge patient advocate that lots of us in the community know. So, but if you don't know, Jonathan Zaid is the founder and executive director of Canadians for Fair Access to Medical Marijuana, and a part-time knowledge integration student at the University of Waterloo, which I did not know. At the age of 14 in 2007, he was diagnosed with new daily persistent headache, a rare neurological condition that causes constant head pain and insomnia. After trying all available interventions with no avail, Jonathan finally gained some relief from medical cannabis. Thank goodness. In 2014, Zaid was among the first to successfully advocate for medical cannabis insurance coverage and help eliminate the fees Ontario-based physicians were charging patients for cannabis authorization. So thank you from all of us for that. In an effort to build on his work, Jonathan founded CFAM to further improve the rights of Canadian medical cannabis patients. Under Jonathan's leadership, CFAM has grown to be one of the most respected and vocal medical cannabis patient groups, which is, it's true, if all the media, it's always you, which we appreciate because it's always, like I said, very articulate and spot on. Zaid currently sits as the chair of the Canadian Medical Cannabis Council's Patient Advisory Committee and is an editorial board member for Using Medical Cannabis, a quarterly medical cannabis publication. Zaid is recognized as Canada's leading industry expert on cost coverage of medical cannabis and other patient-related issues. He is widely seen advocating for patients' rights at various conferences and panels and is frequently featured in television, radio, newspaper, and blog interviews. Everybody welcome Jonathan Zaid to Vapor Central. Anyone, they'll turn it on for you, the middle one. And you're talking today about cannabis and driving, right? Perfect. So again, we'll have some question time at the end, if you don't mind. Perfect, and start us off. Thanks again for coming.
Thank you so much for having me here. And I know it's maybe not the most exciting, interesting topic, impaired driving, but it's one that really is the most pressing policy issue, especially facing medical cannabis patients. So we have a lot of work to do. And a little bit about CFAM, Canadians for Fair Access to Medical Marijuana. We're a national nonprofit patient advocacy group focused on medical cannabis access, education, and research. And one of the topics that we really have focused on, in addition to insurance coverage, access, affordability, we also are focused on impaired driving. And also as part of my studies, in collaboration with Jenna Valeriani, who many of you may know, we released a report, a first of its kind report on medical cannabis specific impaired driving. And we do think that there's special considerations when talking about cannabis used within the medical context, and that's why we authored this report. And there is a lot of literature on impaired driving. We hear this in the media. There's reports that say cannabis may make you a safer driver. There's reports that say it greatly increases fatalities and risk of driving. So we tried to take a really unbiased stance and looked at this issue from a patient perspective and see how the current policy affects patients, how the future proposed Bill C-46 with legalization is going to affect patients. And we also looked at the science and policy in other jurisdictions to see what could be done. So I'm going to walk you through a bit of the report. It's available at cfam.ca for free if you want to read the full thing. And please feel free at the end to ask any questions as well. So just to start off, so I think we're all on the same page. It's a good place to understand what the current laws are on impaired driving. It depends on the provinces, but from the criminal law perspective, drug impaired driving is currently against the law. The way police officers will get to a charge is on reasonable suspicion of drugs while driving. They will conduct what's known as a standardized field sobriety test. And there's limited evidence that shows that some of these tests do relate to cannabis impairment, but for the most part, these tests were developed for alcohol impairment, so they're not fully relatable. And then there's a further evaluation that specially trained police officers can do, known as drug recognition experts. There's not many of these across the country, but they do a more thorough process, and I'll walk you through a bit about that. So that's currently what exists today. There's a lot of problems associated with the system. It's not easy for police, so there's a lot of pressure from a policing perspective to create a system more akin to alcohol, where they have very clear-cut numbers to determine what is so-called impaired driving. But of course, this is part of the divisiveness of the conversation, determining impairment and what it is. And just to give you an understanding of the public polls that face this particular issue, not necessarily particular to medical cannabis use, but drug-impaired driving from cannabis as a whole, it is the #1 public concern about legalization, drug-impaired driving. We have a lot of work to do to properly educate the public on what the research is and what the risks are potentially or not, but the fact is that 60 to 84% of Canadians are most concerned about drug-impaired driving in the context of legalization. So this is a widespread issue, and just as the government approaches legalization, I think we can't kid ourselves. As much as it is a policy issue, it's also a political issue, and as this is the #1 public concern, the government is clearly coming in with a strict approach and wants to look and have a tough approach to drug-impaired driving to subside the public fears about it. And part of the report, we really think it's important to understand what impaired driving means and what presence of drug means. So when we talk about drug-impaired driving, we believe that means when your cognitive motor functions, when your actual physical ability to drive is affected by use of drugs. So this means that you're actually impaired, you're posing a safety risk to others, and that's what impaired driving should mean. Compared to lots of the time when the government speaks to impaired driving, they're really talking about presence of THC in the system. They're not talking necessarily about true impairments, such as, risky driving behaviors. They're talking about having a specific level of THC in your system and then correlating that to impairment. But the science really just isn't there compared to the same way it is with alcohol, where there's a very linear correlation between blood alcohol concentration and your actual levels of impairment to drive. So in the government's bill, C-46, they're proposing to include oral fluid testing. So this will be if a police officer has suspicion that you have drugs in your system, they can conduct a oral fluid test. This is a swab inside your mouth. It's not the most accurate tool, and the government, I think, recognizes that in the bill and in their approach by being a first line of evidence gathering rather than actually proving a criminal charge by virtue of a positive result. On the basis of that or other evidence, the police officers then can conduct a blood test, and there's per se limits that the government is proposing. And this is similar to blood alcohol concentration. So a per se limit means that when you exceed the limit within your system, this will trigger a criminal charge. And it's not necessary, so this is a very important consideration to understand, that a per se limit is not necessarily a measure of impairment. And the government recognizes that to some extent, right? So that you need to get reasonable suspicion and reasonable grounds to get to the blood test. So you need to show signs of impairment. But once you get there, so those signs, we're not sure what those look like. It could be things like smell or bloodshot eyes, which I would argue aren't necessarily signs of impairment. But once the police officer does that and you get a blood test and you exceed a per se limit, then you will get criminally charged. And that's what the government's proposing. And they're proposing a 2 nanogram THC level as a lower summary conviction charge. And that's 2 to 5 nanograms per milliliter of THC. Above a 5 nanogram blood level of THC is a hybrid criminal offense. So that's a pretty serious offense akin to what alcohol DUIs would be. And then there's also another charge created for a combination of both alcohol and cannabis in your system, recognizing that this is a higher risk factor for impaired driving. In terms of the actual risks of driving with THC, and it's, again, important to consider it's THC, not cannabis. Cannabis, as we all know, is very dependent on its chemical constituents, and strains have different reactions on people. So again, when we talk about something like the smell of cannabis in the car necessarily equating to impairment, what happens if that's a pure CBD strain that a patient is using? That's not necessarily risky to drive with, right? So we're talking about drug-related risks of THC in this context. And there is a few different meta-analyses that the government and other stakeholders frequently look at that we've collected in this research report. And they find between 1.16 to about a 3 times risk of impaired driving from THC. And this looks at acute generally recreational consumption, where a non-regular user of cannabis will come into a lab, they'll smoke a joint, and then they'll go for a driving test. And I don't think that's a necessarily indicative way of researching cannabis impairment, because from a research perspective, and especially talking about a medical cannabis patient perspective, that's not how patients use cannabis, right? They're recommended to wait 4 hours after consuming THC products, especially at the beginning, before driving. And regular use of cannabis, you get a better understanding of the effects, and we'll talk a little bit about how this relates to the per se limits from a blood perspective, about how a medical cannabis patient will have a sustained blood level of THC in their system, and again, not necessarily related to impairment. And I think there's a passage that we quote directly, and I think it's a really important one to read. So I'd like to read that, and it's from a study known as Rogerberg and Elvik, 2016. And it says, while our estimates suggest that the impact on crash rates would be a low to moderate risk, even if this argument were correct, we would stress that such simple extrapolations are unlikely to be robust to larger policy changes. Driving under the influence of legal cannabis would probably be made a direct target for policy, leading to efforts with documented effects from the alcohol field. And I think when you consider this passage, we can see this playing out in reality. The science isn't necessarily related to the public policy conversation. And what you may personally believe is not necessarily related to how governments are reacting to this issue. So I think it's really important from an advocacy perspective that as a good advocate, we come at this from a place where the government can understand where we're coming from. And I think that has to be considerate of the science that's out there that shows that, in some instances there is an increased risk, but also understanding there's a lot of public fear about this. And just as much as we may personally believe cannabis may not impair you, we also have a duty to prove that. And the science isn't necessarily fully there to prove either side. And we'll talk about the government's precautionary approach, recognizing that the science isn't there, and in that case, come with a precautionary approach to this issue. And we can see that throughout the government's messaging and policy objectives in this issue. So when talking about a 1 to 3 times increased risk, that's from a laboratory perspective. That's not necessarily some other studies that have looked at this on a more epidemiological level. One commonly cited study from the National Highway Traffic Administration in the US found that there was no increased risk following legalization, and found that there was no THC increased risk. And then the AAA also had a similar study that found a very minor risk correlated to THC impairment and cannabis impairment. So there is quite a varying amount of research out there, but that really clouds the conversation and doesn't give clear guidance for anyone with what the real answers are in lots of these instances. The accuracy of testing is something we also looked at, the standard field sobriety testing as well as the DRE. Both of these are fairly inaccurate and not aimed at cannabis. So we do have concerns about their proliferation, especially looking at this from a cannabis impairment perspective. Again, the DRE and the SFST, the standardized testing, looks at things like smell, looks at things like bloodshot eyes. And yes, these are indicators of cannabis use, but they're not indicators of impairment. So we're really focused on impairment. And as an organization, CFAM is very much against impaired driving by cannabis, by anything. But when we talk about policy, we need to ensure that it targets impairment and doesn't target these other associated things with previous cannabis use. So, given the inaccurate testing from a sobriety testing level, and given the policy objectives of the government, there is research being done to more accurately hone in on a level of THC in the blood that could correlate to impairment. But really, this is not the same as alcohol. THC is a different substance than alcohol. It's metabolized through the fat, and it really does react differently, especially from a patient perspective. Sustained use of oral THC has been shown in studies to be still present above a 2 nanogram limit at the 7-day mark, meaning after 7 days of abstaining from cannabis use, you could still be charged under a 2 nanogram level per se limit. And that's really concerning. There's no studies that show any impairment after 7 days of not using cannabis, and then saying we still have a limit that you may be charged under. That's a really problematic policy from a patient perspective. So we do need to come up with an approach that targets impairment and doesn't necessarily criminalize patients who are using responsibly and aren't impaired. And the risk of simply just raising the per se limits to a point that wouldn't catch patients would not fulfill the policy objectives of the government either. So if you raise the limit up to, let's say, 20 nanograms per milliliter, this may help protect patients, but it's not going to help catch novice users or occasional users who may truly be impaired, but not exceed this limit. So it's kind of a catch-22, right? So there's really not a precise limit that today can say certain people are impaired and others aren't. Really, it's an arbitrary limit the government's going to set, and I think there's going to be a lot of work from a litigation perspective, of course, coming from this to help protect patients that aren't impaired and getting caught in these laws. And part of it, of course, is the administration of cannabis, is patients microdosing or using cannabis in more non-traditional ways may be caught up in a per se limit, and there's no considerations of medical use from a policy perspective in Bill C-46. So really, we need to see different policies across the country to ensure patients are protected. And one particular jurisdiction that's very concerning, and already a bill that's quite well through the legislative process in Manitoba, Bill C-20, I think it's 25, is targeted cannabis use, and I think we'll see this in Ontario too, where no cannabis use is allowed in a vehicle, and there's patients that are members of CFAM where they have seizures in a car as soon as they go into a car. They're not driving, of course, they're just a passenger no matter what, but they need to use cannabis within a vehicle, and these kind of considerations aren't being made. So there's going to be a lot of individual circumstances that we'll have to see how it plays out. Tolerance is also looked at in the study. Of course, patients or regular consumers of cannabis built up a tolerance to the effects of THC. And this is an area where it's actually quite interesting because there is not necessarily the evidence to support tolerance as a reducer of impairment. It does from a subjective perspective, but there is still evidence to show that tolerance doesn't necessarily correlate to all functions needed to safely drive. So this is, again, an area from a research view that we really need to push and get really good quality, well-designed studies done in this area so we can have solid answers. And one thing that is also very concerning is that right now doctors across the country are telling patients wait 4 to 8 hours depending on how you're using cannabis to drive after consuming. And right now patients are doing that. Generally, I would say responsible patients are driving safely under those rules, but in the future, with the per se limits that I discussed earlier, patients following that guidance may still be criminalized. So even though they're following safe use guidelines by colleges of physicians across the country, they still may be arrested by following those guidelines. So we do have a lot of work in the next coming months. If this is the policy the government truly does take up, then patients need complete re-education to understand the criminalization elements that they may be facing. And on that note, we're doing a lot of work with government relations. CFAM is a very collaborative organization and works with various stakeholders. So we are meeting with all different federal areas that are looking at this issue, as well as various provinces. But I can tell you that I think that the government is really steadfast in ensuring they have a strict approach. So we need to come up with good solutions that protect patients, but also ensure that impaired drivers are taken off the road. And there's some examples of this internationally. I would say the UK has the best example, where they have what's known as a medical defense. So that is, you may still get taken off the road, but if you exceed a per se limit and you don't have objective signs of impairment, like dangerous swerving driving or other things along those lines, or you don't have an accident, then you can actually use your prescription and following those kind of safe doctor's orders guidelines as a medical defense. And this allows the courts to expunge the charges so that you don't get criminally charged for exceeding a per se limit without any signs of impairment. And I think that this is something that the government here should strongly consider. And if anyone's interested in developing policy in this area, please feel free to reach out. And on that note, I'd also like to end with a passage from Health Canada, just to again illustrate how the government is approaching this from a precautionary approach. And they say, a key feature of managing health risks is that decisions are often made in the presence of considerable scientific uncertainty. A precautionary approach to decision-making emphasizes the need to take timely and appropriate preventative action, even in the absence of a full scientific demonstration of cause and effect. A lack of full scientific certainty should not be used as a reason not to take preventative measures when reasonable evidence indicates that a situation could cause some significant adverse health event. And I think that this is clearly how the government, at least how from their perspective, it seems that this is how they're approaching it. They're approaching it understanding that there is some evidence showing that cannabis may not be impairing. There's also evidence that does show it's impairing. And until we have the full answer, until we have solid evidence that can fully prove it is safe, we're going to do something that is going to ensure public health and safety. And while that is great, and I totally agree with that's a good policy objective, that shouldn't come at the cost of unfairly criminalized patients. So it's really important that patients are protected when they're not impaired and using responsibly. So thank you so much, and feel free to ask any questions.
7 days? I wish I stayed baked for 7 days. Am I right? Any questions? I think that was only because you were so thorough. Like, that was great. And you were with it in 20 minutes. Like, you nailed it, like you said you would. If you have questions for Jonathan, where can we follow you, keep up with you, or your CamFam, CFAM?
CFAMM.ca on Facebook or Twitter as well. Canadians for Fair Access to Medical Marijuana. And yeah, feel free to reach out right through their website, and I'll get the message as well. So
yeah, you cover everything in terms of cannabis rights. So insurance questions, access questions. You can even Google stuff. It's all online, things that you've said and written before. So thanks so much for coming down, and let's give a warm welcome to Jonathan, everyone.